Welcome to Clause 8. My name is Eli Mazour, and today we're incredibly lucky to be joined by David Kappos. He's, of course, the former head of IP for IBM, former director of the USPTO, and now partner at Cravath. There's a new book out called Tailspin that talks about everything that has gone wrong in the U.S. government for the last 50 years, but you come up for a very different reason. He talks about how you are a superstar as a USPTO director and says that our leaders need to get thousands of David Kapposes to jump into Washington's trenches. So I just want to start by, do you have any advice for future administrations or even the current administrations, how they can identify the right people to serve in similar roles?
Yeah, great question to start with. So I'd say, to be effective in a leadership role in the government, you need to have leadership experience in the private sector. And that probably is one of the most important things that's hard to come by. In addition to leadership experience, it's very helpful if you have management experience. Management is different from leadership, right? But you really kind of need to have both of those sets of experiences. And in addition, to be effective in a place like the USPTO, you need to know the domain. So you kind of need to be a patent person, since that's so much of what the agency does. And you really do need to be a trademark person, too, someone who's dealt with and is facile in the trademark world. And then the last set of skills, you need to have a facility in the policy area. So you need to have been around Washington, D.C., and become known to and trusted by members of the applicable committees of jurisdiction and the staff and people on the relevant courts, including the federal circuit. Eli, what I would say is you need to look for people who have the broad range of experiences that really equip them to be effective in such a job.
So hopefully we can talk more about your USPTO experience, but I really wanted to start talking about the recent IBM versus Groupon verdict. Obviously, IBM was awarded $83 million in that lawsuit. What was your reaction when you heard about the verdict? Well,
so I'll first say I have no involvement in that case. I have no confidential information or access to no insider information on that. I don't think I've talked to anyone at IBM or, in fact, anyone about the decision. I was aware of it. I guess my reaction was, good going IBM. It's terrific to see, a big win like that. And the other thing I was thinking is that any company nowadays that is able to successfully enforce a patent that involves software is really running quite a gauntlet and achieving almost the unachievable with the devaluation and the vilification that's gone on against software patenting and biotech patenting for that matter. So great on IBM winning that case.
Do you think, for example, an independent inventor or even a well-financed startup would have been in a position to bring that kind of lawsuit either through contingency or in any other way, or is that really not realistic for software?
Yeah, probably very difficult because there's probably few and far between are the contingency firms that would take a software patent on now, knowing how vulnerable they are.
I guess right now in your role, I heard you talk about that now you give advice to large investors, whether they should invest in a company based on a company's patent portfolio and so forth. Does this verdict give you more confidence, or is that just, that's just a data point?
Yeah, it's a data point, but one verdict alone can't really give more confidence. I have been called on to give just that kind of advice, and I have to unfortunately admit that the advice I've had to give has caused investors to walk away from investing in innovative software companies because, to be honest, I've had to tell them, this company looks, choose a company XYZ. The technology looks great. I'm very impressed. It looks like they've really got something that can save lives and be, a great addition to humanity's, trove of great products and services. Invest in this company by all means if you have confidence in the management, if you have confidence in the market leadership, if you have confidence in network effects, if you have confidence that they can keep their technology successfully as trade secrets, but don't invest because of the patent portfolio in the case of software and biotech because it's so very vulnerable. And unfortunately, in instances I've been involved in, that advice, as honest as it is, has caused the investors to walk away. So you can just start counting the companies that aren't formed, that don't get funded, the products that don't go into the marketplace, and the human lives that are lost because of innovation stalling out. And I have to assume, Eli, that if I'm giving this advice, there's got to be thousands of other IP attorneys in the U.S. and around the world giving just the same advice.
Maybe not the verdict alone, but do you see, I guess, in the near future, any policy changes or the courts behaving differently, Congress finally taking action where maybe in the future where a company comes to you, you'll say, well, these patents maybe are not worth anything now, but maybe in 5 years. Obviously, it's a case-by-case basis, but in general, do you see your attitude towards that shifting at all?
Yeah, it's not, I would say not yet. There's lots of energy now in favor of congressional action addressing the unpatentability, the unfortunate unpatentability of software implemented innovation, but we're years away from having a congressional solution, if ever. And the Federal Circuit, as much as it's trying to work with the law, work with the world as it sees it, is very hamstrung by the Supreme Court's decisions, and similarly with the U.S. Patent and Trademark Office. So I'd say it's not possible to be optimistic at this point or to give any sensible advice that says you can wait this out, because I'd be saying you can wait this out, but I have no idea how long. It may be 20 years.
Right. Actually, I know you can't talk about any confidential, but I looked it up, and most of the IBMs that were involved in that trial were either the applications were either filed while you were at IBM or the patents were obtained while you were at IBM. I guess, can you talk a little bit about how you thought about IBM's patent acquisition strategy? Obviously, it's known for doing it a little differently. And connected to that, I guess former Commissioner Robert Stoll said that he sees more and more companies are trying to get less patents but are paying higher fees, kind of try to get more high-quality patents. Have you been seeing similar trends? Is that something that you think is an advisable strategy?
Well, yeah, Bob, of course, is a good friend, and I do think we're in an era now where quality really begins to matter a lot because of the constriction of patentable subject matter, because of the raising the bar on obviousness, because of the cases that have created new issues and requirements relative to enablement and written description. So I think, all of that and more puts us in a world in which innovators are benefited by having very high quality patents. And, in a fixed cost world where you don't have infinite money to spend on your portfolio, if you're going to be investing in getting higher quality patents, you're necessarily going to be investing in getting fewer of them. So I do see that as a bit of a trend. And in fact, you see that playing out in the USPTO with, Americans filing fewer patents. The growth in USPTO now, as I understand it, is all coming from Chinese applicants. And they're indeed offsetting decreases in filings by American applicants and causing the net aggregate growth rate at the PTO right now.
That's interesting. So I guess I wanted to talk a little bit about your background. I guess you were already at IBM when you went to law school, but did you have a dream job in mind when you started law school or when you started in a legal job at IBM?
Yeah, so I'm a classic example of someone who had the aspiration of just being a patent attorney. I love the idea, and I did write lots of patent applications of just working with innovators, inventors, understanding their inventions, and writing and prosecuting patent applications and doing a great job on that. That was really the ambition that I had. At the time, I didn't feel particularly comfortable with public speaking or on-your-feet kind of advocacy. And I felt like the ability to ponder and think and be deliberative was perfect, and that patent prosecution afforded all of that.
Was there a certain point in your career at IBM where you thought, well, maybe I'm on the path of being the head of IP at IBM?
Yeah, well, at some point it becomes clear that, or possible or probable that those kinds of things are going to happen. But for me, career development has always been very organic. I've loved every job I've ever had, anywhere, including the current one I have and the PTO job and all the jobs at IBM. So I was never unhappy in any of them. I was always actually happy in them. And then another opportunity came along, and I said, okay, I guess I'll go try that new thing. So it's been very organic for me, and I would readily admit unplanned.
From your time at IBM, do you remember any challenging situations that either you personally or the IP team there faced? I guess how you dealt with that, anything that stands out for you?
Yeah, it's been a while. It's been, I think, 10 years or longer since I was at IBM, so it's a little difficult to remember now. But there are, plenty of challenges. The IP department in IBM, and it's not at all confidential to say this, is integral to producing really significant licensing income for the company, and always has been. And so there's a tremendous sense of responsibility and lots of challenges with the licensing negotiations that you're constantly undertaking. And I can remember back to those days many challenges involving licensing. The other thing was, at the time, in addition to IBM classically doing lots and lots of acquisitions, and that's all a matter of public record, of course, we were divesting some important businesses, including the disk drive business and what was then the IBM PC business, to Lenovo. And those were hugely challenging deals and very complicated, essentially trying to take a completely integrated business lines and separate them and then divest them. So if you talk about challenges, all of which ended very successfully, I think it's fair to say those are some of the big ones that I think of.
And I guess I have two connected questions. Obviously, when you were in the top role there, you had a lot of things on your plate. How did you decide what to focus on? And then I guess a connected question is, let's say you're IP counsel at a large company, but with a very small IP team. And most of your day-to-day is filled with just managing the patent prosecution docket, for example. What are the blind spots that you think IP counsel have out of a role, or what would you recommend that they should be thinking about?
Great question. So the first one, the way I think about management is always asking the question, is there someone else who can do this? Whatever this is, the thing that you're looking at, is there someone else who can do it? And if there is, give it to that person to do it. And that always ensures then that as the leader, you're focusing your attention on the stuff that only you can do, that there isn't anyone else that can handle it. And that way you're spending your time on the strategic, on the big ticket, on the policy, on the stuff, again, that you really need to spend your time on. So that's just how I have always handled delegation, including when I was in charge at IBM and at the U.S. Patent and Trademark Office. And people don't react badly to that. They actually react very well to it, because people want to take responsibility and they want to do stuff that's important and they want to be empowered by management. So all of that works out in a very symbiotic way. In terms of your other question, now go back and restate that again.
So let's say you're IP counsel
at a small
at a large company, but there's a small IP team. And
how do you deal with, what are your blind spots there?
Yeah.
So first and foremost, if I'm at a large company and I'm running a small IP team, and I see this here at Cravath, because the folks in those jobs, call on us and ask me for help pretty regularly. The kinds of things that are the blind spots that'll be real problems are, number one, if there is an adverse patent situation, some third-party patent that's going to come up and bite you, and you want to know about those if you can. Even if you got a small team, you want to be constantly looking at what's going on with your key competitors. Those are the ones who are going to file strategic suits and problem suits against you. Patent trolls, not that big a deal. Everybody understands they, to a less extent now than in the past, but still occasionally you'll get hit with something like that. That's very tactical. That's small ticket. I don't get nervous about that stuff. The stuff I get nervous about is our biggest competitor, who we should be watching, coming out and stopping a product. And that's the stuff you don't want to get burnt with. That's on the defensive side. On the offensive side, you never, even as the leader of a small team, you never want to be in the position where you let a patent go or a trademark go because you didn't think it was important, or because you didn't know it was important, or for whatever other reason. Because that stuff's hard to explain. Your key assets, you want to be understanding them, monitoring them, ensuring that they're maintained, whether they're patents or trademarks. Copyrights are a little more self-maintaining. trade secrets, I think somewhat self-maintaining, but in that same category of you wouldn't want to, like, for instance, not have a badging policy or a policy of marking confidential information with legends, and then later on lose your trade secret portfolio and have to explain to the board, well, I wasn't paying attention to that. So that's all. To go to the point I made before, even if you're the manager of a small department, you got to be delegating everything you can so that you're looking peripherally and at the horizon and picking up those issues that can bite the company going forward. And then the one other thing I would say is, no matter how busy you are marshaling, a portfolio and filing applications and all of that day by day, I think you're never too busy to be looking at technology trends as an IP lawyer. That's what we do. We're tech folks, looking at technology trends that are coming over the horizon and thinking about how to position your company to take advantage of them, to get benefit from them and leverage from them, and especially not to get burned by them. So those are the things I think of.
That's all great advice. I guess one last question about your time at IBM. Do you remember while you were there and obviously progressing through the ranks, when you started thinking about policy making in DC, and what did you think at that time was your role in trying to influence that?
Yeah, so I started getting involved in DC policymaking, really I would say even before I was the chief IP lawyer at IBM, but somewhere around the year 2000 when I came back from assignment in Tokyo and started spending time traveling to DC, involved in policy circles there, and then that just accelerated over time. And my role then was to help policymakers understand the IP implications of the things they were looking at. These were in the very earliest days of starting to think about what became the AIA. Yeah. And it was, so we were trying to get the national academies to come out with a study on the IP system that advocated for some positive changes. We were trying to get other groups to put together studies and to create data, if you will, to create points of reference for us to then advocate. We were working on what became first drafts of the initial attempts at the AIA, which had many pieces of legislation in them that were very hard to get done, like injunction language that really could only be solved by the Supreme Court, ultimately in the eBay decision. So those were the things that we were doing way back then.
Did your thinking change about what's effective at, I guess, influencing IP policymaking after you were USPTO director? Any strategies that you wish you kind of knew about or thought about after you were USPTO director that, I guess, you didn't think were as effective, or maybe vice versa?
Well, when you're inside the administration, you become a lot more aware of all the levers that are available, and particularly the subtle ones within the White House, within the Department of Commerce, working staff to staff. I mean, you've got a lot more ability to move policy inside the government than you do outside. So a lot of it is similar, for instance, going in and meeting with members and staff and looking at and reviewing and helping to edit or comment on drafts of language. But it's very different when you're inside the administration and you can actually, convene meetings with congressional staff and sit elbow to elbow with them and work on the language together as one team, as opposed to if you're in the private sector, you can never do that. And that leaves aside, bringing in the Secretary of Commerce, marshaling the resources of the entire administration, including the White House, all of which you can do when you're inside the government leading the USPTO, and you have really, no hope. You feel like you're pushing on a rope trying to do those kinds of things from outside.
Even for a company like IBM that has presence all over the United States, a huge employer, but even a company like that has...
Yeah, sure. Corporate interests are respected and listened to, but at the end of the day, folks inside the government are trying to think about broad policy on behalf of the entire country, right, and take lots and lots of interest into account. And, then it's your job at these agencies like the USPTO to do that. So when you're in the government and you're doing that, you have a huge leg up.
So now I guess I want to talk about, obviously, your time at the USPTO. Can you briefly tell us about how that came about? When did you, decide that you were interested in becoming director? Was it a formal process to apply, or how does that come about?
Yeah, I didn't really have any formal process or decide that I was interested. I never asked for the job or lobbied for it or sent anyone flowers or told anyone I wanted the job, and none of that. I was called by then new Secretary of Commerce Gary Locke shortly after he started, and he said, look, I've been told that you may be able to be helpful here. Will you consider coming to D.C. if you were offered that job? And of course, I went and talked to my wife, who said, okay. And then I said, all right, if you want me to do it, I'm happy to do it. So it was pretty much that simple for me. And again, very organic. Like I said before, I've never asked for any of these jobs.
Because, you read about people trying to get in, but it seems like they went to find you. And
that was definitely not the case for me. Yeah.
I guess I want to try to understand, I think you touched upon it somewhat, but from a practical perspective, what influences how the USPTO acts? So maybe you could talk a little bit more about it. Does the White House, the Commerce Department give you broad policy goals in the beginning of administration, or is that too Pollyannish, or do they give you their opinion about every single issue? How does that work, I guess?
Really, I found it was more the opposite. So the director of the PTO is statutorily charged with advising the administration on IP policy. So when I started, in fact, even before I started, while my confirmation was pending, because there was such a vacuum of knowledge early in a new administration, this is in the summer of 2000, spring really of 2009, I was working already then informally, and then of course after I started very formally, helping to craft IP policy for the new administration. There was never any, here's what you're going to do. It was always, tell us what our policy should be in the IP area. And then shortly after I formally started in the summer of 2009, the very adept political people at the Department of Commerce convened a large meeting over in the White House in the Eisenhower Executive Office building, actually, and sat me at the head of it. And we scripted out ahead of time that this was going to be the meeting in which we said, all right, now we got a leader of the USPTO. Everybody else around this table, get out of the way, because the leader of the PTO is now calling the shots on IP policy. And we did that. And we had that very meeting and proceeded from there.
I was surprised, actually, in that book, Tailspin. It talks about how, for example, when you were going to change the rules for examiners, giving them more time to examine applications, you had to get buy-in from the Commerce and the White House Department. I guess from the outside, that seems like that's a small issue that should really impact what's going on within the PTO. But I guess did that surprise you that you had to get that kind of buy-in from the people outside the USPTO, or?
Not really. I was used to operating in a large enterprise where there are costs and benefits to being, if you will, a cowboy that goes out and just does whatever, or a loose cannon that goes out and does whatever you want and then asks for forgiveness later on, versus a team player who tries to understand what your level of autonomy is and should be, and also understand where you need to check in with your teammates in order to gain their support on everything else you want to do. So, I was cognizant that I came in to try and get some big things done, including what became the AIA. To get that done, I needed the White House and I needed the Department of Commerce. And to get them on side, I was going to have to play team ball from the beginning and work with them on things that you might think are, kind of inside baseball, like how many hours you give examiners to examine applications. Also, the Secretary of Commerce, Gary Locke, who is a wonderful boss, was very concerned from the beginning about pendency and the backlog. Those are things you can measure. Everybody knows about those. They were things that at the time, I know, now people don't talk about that much because the PTO's got pendency and backlog pretty much under control.
Right.
They're near optimal levels. But at the time, that was not the case. The place was in free fall. The backlog was 1.2 million applications. Pendency was 46 months or something like that. It was terrible. The situation was a mess, and Secretary Locke was very focused on that. So I knew that if I was going to increase the time examiners had to examine applications, that could cause the backlog to get worse and pendency to get worse. And I was not going to let that happen and blindside my boss with it when he's out saying these are really important issues. So I had to navigate all of that, and that's why you go in and you tell your boss about it and you explain why it's a good thing. And to his great credit, he was very quick to pick up, yeah, you got it. He said, I got it, you got it, go do what you need to do, this is going to work, and it did.
I really think one of your greatest accomplishments as USPTO director was really changing the culture in terms of encouraging examiners to conduct interviews. How did that occur to you that that's really the solution to the problem with the backlog? And how did you, make sure that policy was implemented? There were examiners there for, decades before you came around. And how did you think about making sure that those changes take place?
Yeah, so that's a great one. So first of all, I'd say that the culture change at the PTO, which, by the way, I don't know if you've ever seen, I actually have the poster in my office, went from being near the bottom in terms of agency rankings to the very top agency, the number one agency out of over 200 agencies in the federal government. And I laugh a little bit because it's so improbable when you're up against agencies that get to do fun things like explode bombs and put people in space, and, kind of really cool, sexy stuff that some of these agencies get to do. And somehow or other, against all odds, we managed to get to the very top spot as the highest performing federal agency. So that happened not because of any one thing like interviews. Interviews were visible, which is why people knew about them, but it's really about, like any major change program, it's about a lot of little things. So that was really the trick more than any one big thing. The examiner interviews, though, I didn't think they were any panacea. They weren't the full solution to the problem, but they were part of a larger scheme. And if you went back, I don't know if they've archived this stuff, but one of the things we created very early on, immediately when I started, was a director, what we now call a blog. We called it the Directors Forum. Yeah. That didn't exist before 2009. And in fact, at the time, blogging was not a big deal. And so when I first started and asked, can I start blogging? I was told, yeah, whatever. We don't even care about that. Since then, there have been lots of rules put in place, and I think that makes sense. We opened up this channel that enabled us to start communicating with examiners and with the constituencies of the USPTO. And we were just flooding that blog channel, the Directors Forum, with messages to examiners that were very much aimed at building up confidence of examiners to just do the right thing, to empower them to do what they came to do in the first place, which is examine patent applications and use their judgment, and don't be afraid to say yes and don't be afraid to say no, be guided by principle. And so getting that message out and letting everyone step back and giving them the confidence to do that and the training to do it and the vehicles, and this is what you're pointing to, to codify examiner interviews as being a good thing and put the structure around them so that there was a sufficient amount of documentation that occurred at the end of one of these interviews, or to explain what happened in one of these interviews, while not succumbing to the demands of some folks who wanted interviews to be recorded, which of course would have such a chilling effect that they'd be totally useless. So, we had to step up, create enough process, listen to folks on all sides and explain to those who weren't going to get their way why that didn't make sense, and do what we could. But most importantly, again, stepping back, I'd say most importantly was giving the examiners the confidence to go do the right thing, because they already knew what the right thing was. And they want to do these kinds of things like interviews and reaching out to applicants to agree on claim changes to get cases in condition for allowance. They wanted to do all of those things. They just needed to be told, if you will, or they needed to have the support and know that they'd have the backing to go and do that.
As you mentioned, another major part of your time at the USPTO was really helping get the AIA passed and implemented. It seems that you've said it yourself, and Senator John Kyle, who was involved in the process, said as well. It seems like you overcorrected on whatever the problem was out there. Is there anything that you would have done differently with regards to the implementation of the AIA? Is there anything that you could have think that Congress was realistic for the Congress to go into any different direction? If you knew of a way to default?
Yeah, to the second question, not really, because that legislation was so complicated that there was really no way, you were going to have the crystal ball to foresee the future and do everything perfectly. So I actually think Congress did a remarkably good job on that legislation. Now, you can quibble about things like the on-sale bar and the language there that's a little bit squishy that's now, going to go to the Supreme Court, and we'll get a decision on that. But I don't even fault Congress for that, because there's some things that need to be sorted out by case law developing. And they had, and I credit especially Chairman Smith from Texas and Chairman Leahy from Vermont on having the wisdom to know, where to sort of stop, because some things were just going to have to get sorted out organically through the court system. So I think Congress did a great job. In terms of our implementation at the PTO, I think, Eli, if you step back, the team that implemented the legislation, and I say the team because the whole agency really was heavily involved, did a remarkable job. You would have, if you cast your eyes back to 2011 when the AIA passed, and you think about it, it was the first time the agency had ever been asked to stand up an entirely new entity, the PTAB. It was given very strict timelines to work within, which in 200 years it had never been given strict timelines for anything. The only thing that had any time element at all was due dispatch, right, for the reissue statute or reexamination. Yeah. So now suddenly you're in a world in which you've got these very strict timelines, this very ambitious new court to set up, and it's going to be very visible to everyone if you don't get it done. And so the prevailing wisdom would be, of course the PTO is not going to be able to get this done. It could never get anything this complicated done and meet those timelines. But it did. It got it all done, and it's met all of its timelines. Now, 6 years later or something like that. So I think it's remarkable on the part of the PTAB and all the folks at the PTO, and James Smith, who was the first chief judge, that was, saddled with implementing all of that and hiring all those judges, and he just did a wonderful job of all of that. Now, that being said, there's no way we could have done it perfectly, and there's no way we could have done anything if we had tried to do it perfectly, because that's where you get into analysis paralysis. And so the goal from the beginning, and I was heavily on record for saying this, was not to try and be perfect, but to try and get to a 70% solution and then iterate on that. If there's any mistake that was made, it was that the iteration didn't really occur. I promised the community we'd iterate. Others at the agency knew we needed to iterate. And then as time went on, the iteration didn't occur. And I'm not blaming anyone, leaders who followed me, the PTO staff. You could go back and sort of look at what happened, a vacuum of leadership and cross currents with the White House that happened, in the years succeeding the AIA, a desire to get more data, which is always perfectly okay. But what it resulted in is not iterating very much or very quickly. And so you've seen now Director Yonku has come on and done that and started iterating on things and picking up on the data that now shows clearly what we didn't do as well as we could have, knowing what we now know. And he's fixing those things. So it's the iteration that was so critical and we knew was going to be needed that's finally happening, and I think is a really good thing.
Towards the end of your time at the USPTO, you actually gave a speech at the Center for American Progress, I believe, in defense of software patents. From what I've heard, and I'm not sure how accurate it is, the people in the White House were unhappy about that speech. Can you tell us more? Did it seem like the administration took a different turn somewhere in the middle? First, it seems like they were listening to your advice, and then it seems maybe they started to listen to advice from somebody else. Can you talk a little about it?
Well, I don't know about that. So if you try and do things in a job like that, particularly if you try and do big things, there's always going to be someone who's not happy with it. So in my mind, the litmus test isn't whether even someone in the White House was unhappy. That's neither here nor there. What certainly didn't happen while I was still there was any pushback that came to my level that said, you shouldn't be doing this anymore. That would have been more of concern to me, and there was absolutely none of that. In fact, you can look in the record and see one of the final things we did when I was still there was come out with an important policy piece with the Department of Justice setting forth guidelines for thinking about standard essential patents vis-a-vis antitrust issues. That was a major piece of work to get done. And I don't believe anything like that has ever been done before or even since between the PTO and the Department of Justice that advocates for strong and balanced intellectual property rights and standard setting vis-a-vis antitrust issues. I love that piece of work. I think the DOJ did a great job. The PTO did a great job. It was the government working the way it should work, with all the checks and balances and to and fro in place, and then adults agreeing to a great policy solution and putting it out. And the reason I mention that, Eli, is that was very near the end of my tenure. If there would have been problems, someone, OSTP, OMB, White House Counsel's Office, NEC, you name it, someone would have stopped that. Nobody stopped it. That was because we had great throw weight at the PTO, and we had great partnering, and we were doing the right thing. And despite what might be some low-level grousing from time to time, they were still waving us through on these major policy initiatives.
Well, that's great to hear. A few last questions. I guess before the 2016 election even took place, you were talking about how whoever's in the next administration, they really need to prioritize innovation and really taking the right steps with regards to intellectual property policies. I think you already mentioned that Director Iancu is doing great things with that. Is there anything else that you think the administration should focus on that you haven't maybe seen, or any advice you might have, or I guess your overall sense about how that's going with them?
Well, I really like what Director Iancu is doing and the administration as a whole relative to IP. It's interesting that IP is in the news now in a good way. It's on the, above the fold in major newspapers because of the trade wars. Yeah. And I'm not here to talk about those, but there are a lot about intellectual property protection. And so in a, kind of a larger sense, it's good to see IP promoted to the top of the agenda and to see IP getting the prominence that it is. In terms of what's next, I really think it's time now for a sort of an administration policy or an administration statement on intellectual property and innovation. Look, we're in the era of 5G. The administration has declared that 5G is an issue of national importance and an issue of national security. Everyone knows 5G will create entirely new business models, will enable, massive new opportunities for humankind. And the country and the companies that lead 5G will lead in creating the ecosystems that'll create jobs and create economic opportunity and all the other good things that come with that. And the administration's said those things. I'm not making this up. I'm just parroting what's already been said, and it's all absolutely true. And so in that world, the next step that seems just obvious to me is to come out with, whether you call it a white paper or a statement of administration policy or whatever it's called. There's lots of vehicles to do that. But a paper that comes out of the White House that says we're going to lead in 5G, and we understand that to do that, billions of dollars have to be invested by the private sector, and they have to be invested in creating standards. And we understand that to do that, we have to have a strong IP regime, and we understand that it has to coordinate well with antitrust so that antitrust doesn't become an overhang on innovators operating in a standards-intensive environment. And you just tick through what I think are pretty obvious points, many points that have already been made by Macon Delrahim, who's the other senior member of the administration who's doing great work in this regard. And you've got a great White House white paper, administration white paper, that plots a course for U.S. leadership in 5G and all the good things that come from it. So that's the thing that comes to mind for me, Eli, that's just like, all right, time to go off and put this all together.
Right. Yeah, and I was actually going to ask you about what Macon Delrahim is doing, so it's good to hear that. So a few final questions, just quick ones. What advice would you give to a law school student or maybe a young attorney who wants to become the next David Kappos?
Yeah, I don't know about that last part, but to broaden the question a little bit of advice that I'd give generally, a couple of things. One, it's a great field. It remains a great field. IP writ large, patents, trademarks, copyrights, trade secrets, is about where the law meets the future. And that's a really cool place to be working. It has been, it continues to be. Don't let anyone talk you into believing there isn't a future in this field. There absolutely is. That's point one. Point two, there are always ebbs and flows in IP. We went through a period of strong, some would say excessively strong IP in the 1990s after the Federal Circuit was formed and put some bedrock decisions in place. And then we got into a situation where there was a lot of abuse occurring in the first decade of the 20th century, and then we corrected for that with a series of Supreme Court decisions, and then the AIA in the early part of the second decade of the 21st century. And as you pointed out, Eli, and I've said myself, we probably overcorrected between some of those Supreme Court decisions, like on 101, and some of what we did at the PTO. And now we're starting to see counter corrections that are re-strengthening the system. Those will continue. The system will have its ebbs and flows, but it's generally a great system, strongest one in the world, and shows good prospects for the future. The last thing I'd say to new folks in the field is, hey, if you can, go work for the government for a while. It's a great place to work. Work for the USPTO. Work in other agencies that touch on innovation. Learn, contribute, serve your country. You don't have to do it forever, but it's an absolutely great place, and I highly encourage public service.
So one last question, hopefully it's a fun one. If you didn't become a patent attorney, is there any other career path that you think you might have wanted to follow?
Yeah, I was actually perfectly happy as an engineer, so I could have easily stayed as an electrical and computer engineer and been, still doing engineering stuff to this day. I think the whole, innovation, entrepreneurship, technology-related path is a great one for folks now as it was in the past, and provide not only great prospects for getting great jobs in whatever area you want to work, but also great prospects in contributing and creating value for humanity.
That's great. Thank you so much for joining us. Really appreciate it.
Yeah, my pleasure.